All right, welcome to this explainer. Today we're diving into a question that, well, it really gets to the heart of power and justice in Nigeria. Can the nation's top lawyer actually be prosecuted for not prosecuting someone? It sounds like a total legal riddle, right? But believe me, the consequences are very, very real.
You know, this quote really hits the nail on the head, doesn't it? It captures this feeling that so many people have. Whenever something feels unjust, the gut reaction is simple. Just hold the person at the top accountable. But what happens when the law itself kind of gets in the way of that simple demand?
So what kicked off this whole conversation? Well, it was a headline that, honestly, was pretty shocking.
Yeah, you heard that right. The former Attorney General of the Federation himself, Abubakar Malami, was actually in court. And look, this isn't just another high-profile case. This is the legal system basically turning the microscope on one of its own top players. So what was he actually accused of? What led to this moment?
And this is where it gets really interesting. See, Malami wasn't accused of the usual stuff, like taking a bribe or, hiding evidence. The accusation was that his inaction, the fact that he refused to prosecute, was the actual crime. And that, right there, is the big question we're tackling today. Can a decision to not do something be a crime?
Okay, so to even begin to answer that, we've got to talk about the incredible power that comes with being the Attorney General. There's a reason some call this person Nigeria's legal final boss, and it's not an exaggeration.
And this is where what we want to happen slams right into what the law says can happen. The answer isn't about public opinion or outrage. Nope, it's buried deep inside the country's most important legal document. The key to all of this? It's found in one single part of the 1999 Constitution. We're talking about Section 174. This one section hands the Attorney General a set of powers that are so huge, it basically puts them at the very center of the entire criminal justice system.
So, what are we talking about here? What can the AG actually do? Well, they can start any criminal case they want. They can take over a case that someone else started. And, this is the big one for us today, they have the power to stop any criminal case just like that, dead in its tracks.
Now, this incredible power to just stop a case, it has a fancy Latin name, nol prosequi. Basically, it just means unwilling to prosecute. I mean, think about it like a constitutional superpower. It lets the AG end a prosecution anytime before a judge makes a final decision, and they don't even have to explain why to the court. And if you're wondering just how protected this power is, well, listen to this. The Supreme Court of Nigeria has said over and over again that these powers are discretionary. It's up to the AG. That means judges aren't supposed to be second-guessing the AG. The courts won't be, peering over their shoulder asking, hey, are you sure about that? It just doesn't work that way.
So you can see how this discretionary power works like a kind of constitutional shield. Let's dig into how that shield actually works, especially when you're dealing with something as serious as terrorism.
And this, right here, this is the part that gets everybody fired up, isn't it? I mean, the public reaction is completely understandable. We're talking about terrorism, one of the worst crimes you can imagine. So how on earth can one person have the power to just say, nah, we're not going to prosecute that? But when you look at it from a purely legal perspective, the answer is surprisingly straightforward. Section 174 doesn't have a list of exceptions. It doesn't say except for terrorism. The power is absolute. Deciding not to prosecute is seen as the exact same kind of prosecutorial decision as deciding to prosecute. And the thing is, the courts get that prosecution is super complex. It's not what one writer called vibes-based governance. You can't just go with your gut. An AG is looking at things that you and I will probably never see, like how strong is the evidence really? What do the secret intelligence reports say? What are the national security risks? And what if the case is weak and just collapses in court? That could make things even worse.
Okay, but hold on. This does not mean the Attorney General is completely above the law. There are real limits to this constitutional shield, and it's super important to know exactly where that line is.
The big thing to remember here is that the AG is not some kind of demigod. That constitutional protection is for a very specific action, and it doesn't cover everything. There is a line, and if you cross it, everything changes. So here's the absolute key difference. On one side, you've got the protected decision not to prosecute a case. But on the other side, you have stuff that is obviously not protected. Things like taking a bribe, destroying evidence, or plotting with the suspects. That's not exercising discretion, that's just a straight-up crime. And that, right there, is the most important takeaway. Section 174 protects the decision itself,
but it does not protect any crimes you commit while making that decision. So if there's proof of bribery or that they obstructed justice or conspired with someone, poof, that constitutional shield is gone.
So if you can't go to court to challenge the AG's decision, then what can you do? What happens when everyone feels like a terrible decision was made?
This really is the final, and maybe the most practical, question of all. If the courts are not an option, what's left? How can an attorney general be held accountable?
Well, the answer isn't in the courtroom. It's in the world of politics. The real checks and balances here are things like the president, who can fire the AG. You have lawmakers who can apply a ton of pressure. And then there's the court of public opinion, which includes public embarrassment and even what you might call international side-eye.
And this final quote really just wraps the whole thing up perfectly. The Constitution gives the discretion, and public outrage, as important as it is in a democracy, can't just erase a part of the Constitution. The real solution has to be political.
So, that leaves us with one last big idea for you to chew on. When the law itself seems to offer no solution, when it protects a decision that feels wrong, what does the path to real justice actually look like? That's something to think about. Thanks so much for watching.